corridors of justice, rather. Consent and privacy in the digital age. That is the conversation you're having this morning with Wakili Silas Akiru. That is an advocate of the High Court of Kenya. A lot of us record videos, we share voice notes, screenshot chats, or maybe just forward content without thinking twice. But the conversation this morning is that at what point does that cross the line into violation of consent or privacy? Now, online, over the past few days, or rather last week, there's a video that was circulating online that is of James Opande. Just to give you context for this conversation, James Opande is a US-based Kenyan nurse who appears in a January 16 video lifting a lady by the name Marion Napei. This is information that is available online and everywhere. Marion claims that Opande licked it in revenge after she refused to have, a sexual intercourse with the man, while he says his phone was hacked and she harassed him. So it's a blame game here between, of course, Opande and Marion. Now, the 22-year-old apologized publicly, and of course, with help from Nairobi official, she reported the case. Of course, leading to police arrest two suspects and of course to detain Opande at the airport on January 18 under cybercrime laws. Now, the question you're asking this morning, did a criminal act take place in the eyes of the law? Wakili, karibu, and that is your first question.
Thank you very much, Mr. Dida, for having me once again in your studios. I'm very glad to always be here to grace your audience. As has been told, my name is Silas Akiru, an advocate of the High Court of Kenya. To begin or to kick off with your question, whether a criminal offense took place, ideally, when we talk about consent or privacy, the chief law we're looking at here is the Constitution of Kenya. And the Constitution provides for the right to privacy under Article 31. And this particular provision of the Constitution was given breath in 2019 when Kenya enacted, or the Kenyan Parliament enacted, the Data Protection Act 2019. And through the Data Protection Act, we have the Office of the Data Commissioner that came up with several regulations, including the Data Protection Consent Regulations, or consent guidelines, which provides how you're supposed to treat individual data or a data subject's data. Now, in this particular case, we have looked at issues to do with cyber crime and cyber harassment. I think the lady could have rights within the Computer Misuse and Cyber Crimes Act. The lady could also have rights or recourse under the Constitution and as well as the Data Protection Act. Now, expressly or explicitly, a criminal intent would be difficult to achieve in this clip that we are discussing here. Criminal intent would be difficult to achieve. However, a civil intent can easily be construed. Remember, there has been an issue with online trends, issues with the leakage of privacy or private information belonging to individuals. And that has never been able to be cured by the penal code, which is the chief criminal legal regime in the country. And that is why you see majority of cyber crime activities are always handled through the Computer Misuse and Cyber Crimes Act of 2018. And so the achievement of a criminal intent, from the way I analyzed the video, I really am not providing legal advice to she's called Nape.
Yes.
Yes, I'm not providing legal advice on your screens, but had I been contacted in this matter, a criminal intent would be the last option to take.
What first option would you take regarding this matter if you were to be approached?
Now, the first approach I would take in this matter would be a little bit far from privacy. It will be, I will go the dignity way. Because we are talking about every person, every Kenyan having right under Article 28 of the Constitution of Kenya, the right to dignity. Because we are looking at two consenting adults, and then eventually issues are exposed there. And then upon exposure, you see the humiliation. When you look at her sort of apology, which I would have a few questions to ask about, but you see she is expressing real humiliation. She's been humiliated. The family has been humiliated. There are rumors have not confirmed, you know, the Kenyan digital space is quite freaky. They would really even have, so long as they realize you are trending, they already create dummy accounts, and they are now on iPay, and impersonations are ongoing, and then you see an apology coming from. So I don't know if that was her apology, and you see, I've seen statements like she had to pick her child from the current school because of bullying. You see, these are issues to do with human dignity. Her dignity has been interfered with, and her dignity has indeed been abrogated, and therefore getting the approach of a constitutional petition on the basis of human dignity, like my friend, my very close friend, Danson Omari would put it, that really that is the catch.
So what does the law say about sexual violence? Because I've seen conversations around this also online, that this could qualify as something around sexual violence in law. But is there something like illegal recording under the Kenyan, say maybe constitution, or even in the eyes of the law? And also, just as you merge that with what the law says about sexual violence in this context of the video that you're talking about this morning.
Yeah, ideally, we would also have a look at it in terms of the Sexual Offences Act. But again, when you talk about the sexual offences, the lady was, as you say, I wouldn't wish to say that she, at the position she was in, it was difficult to put right-thinking questions to her, and she fails to answer correctly. You know, that is the test of intoxication. That you are at a compromised state to the extent that if I pose right-thinking questions to you, you will not be able to answer them correctly. But now we are seeing an individual, for example, Ms. Odida, who is able to tell that herself she is not properly dressed. And she cautions. And the discussion around there wouldn't, if I were to be the devil's advocate here, and not to be able to categorically construe that she didn't know particularly what was happening around her. I think the only thing in terms of recording, in terms of video recording, in terms of sharing, I mean in terms of storage, that I will not find Opande to the wrong. The only place I'll find Opande to the wrong is the sharing. Yeah? So, because when you look at the conversation, the lady appears not to categorically oppose the recording. And she appears to expressly or impliedly be into that particular recording at that point, because it's her boyfriend, you know. Her only problem was that people were watching. Meaning, at their, facing out the people, then she's okay with the recording. Facing out the people, well, that would be the test. But for the people, she's okay with the recording. Now, where I will find Upande to the wrong would be exposure without her explicit consent. Remember, I may allow you to take video recording of me. I may allow you to even retain and store. But if I don't give you explicit consent to share, then you have gone against the purpose. You've gone against the reason. You've gone against the consent requirements. You're not supposed to share my video without my explicit consent. So that is where I will find this gentleman at fault.
All right. The question we're asking online, and of course we do welcome you to be part of this conversation. In today's internet world, of course, where gossip, which we usually call chai, spreads so fast, have you ever recorded a call or shared content without consent? Did you know it could be a crime? We are talking about consent, Wakili, this morning. You've mentioned it a couple of times, but let's define consent. Recording, when sharing, can it be withdrawn? Just for the benefit of our viewer this morning, define what consent is in a legal lens.
Now, consent in just a language that your viewers can understand is a permission to be recorded, permission for your data to be collected, and permission for the collector to process and use that information, probably to their benefit or the benefit of both of you. So just the permission to be recorded. So if you give that permission, then you have consented. You have agreed it to be recorded. So that is in a very explicit language that somebody can understand. Now, the law requires that it must not just be consent. It must be informed consent. Some legal minds call it explicit consent, that somebody may be able to understand what he is or she is consenting to. Now, if you're recording me, please let me know the reason why I have to be recorded. Understand? And let me know, after you record me, what are you going to do with my data inside your phone or your gadget? And then let me know what avenues or rights do I have. Once I know this, then my rights kick in. I may decline the recording. I may reject after you record, remember, and then you show me what you've recorded. Then I say, apana, this photo. Hii picha si yangu. I know Tom Daktari sometimes normally says, ukitokelezea vizuri kwa picha, post. But at the end of it, for me, I may say, so that I mean I have rejected the recording, and so you have to delete it. Number two, I may withdraw my consent. I have given you consent, but the way I see you handling my data is not as per what you had explained to me. And therefore, I give you I do you a note and tell you, kindly, I withdraw my consent from you guys, delete every data belonging to me that you have. So the data subject has a right to decline. That is now at recording. After you explain to him, no, don't record me. Or allows you to record, but then you get poor data. that maybe compromises his expectations of his data. And then he rejects that recording. Or once he has permitted you to record, you've recorded and you've stored, and then now maybe you want to disseminate, and then he realizes maybe how you are handling the data, he may withdraw the consent. So these three aspects are within the consent guidelines. So if he withdraws his consent and then you proceed, he has a right against you.
Talk to us about silence or prior agreement. Does that count as consent? Say, I just be quiet about it. You post, I just, it just passes by. I don't say anything about it. Does that count as consent? Even when it comes to a point where, I'll stare at that photo or video for a very long time and say, I don't like how I look in this photo. So does that count as consent still?
Ideally, like I said, there are these stages that I've just mentioned. At recording, before you record, you explain to me everything. And then I allow you to record. So after recording from your question, I stare at the photo and then I remain silent. Under those circumstances, my consent is still active. However, if I do not give consent, for example, I walk in here, I don't give you consent to record me, but somehow you proceed to record, and then you post, and then I remain silent. Remember what I said? Consent must be explicit. So you must get the data subject to agree to it. If he remains silent, then it means you went against his rights to record him without, this is now where sometimes we say, recording without knowledge, secretive recording. You've recorded this guy without his knowledge, and then probably his silence is for you to proceed, so that now he goes to the ODPC, the Office of the Data Commissioner, for certain remedies. So if at the beginning he has allowed you to consent, but in the midst, when probably he's inspecting what you have recorded, and then he just remains silent, that means his consent is still active. But if he doesn't give you an express consent to be recorded, but then you proceed to record, no notice, no nothing, and then he just remains silent, the one who is at fault is the data collector, that is the recorder. Yeah.
So is recording content and sharing treated as two different offenses, or does the law see these two as distinct, such as you record and then there's also sharing? Are these two different things?
Not absolutely not. They are treated as one, and that is why the consent guideline requires that you inform the data subject the purpose. Right? So, if your purpose is just to have a clip of the interview today and probably put it in your collection and not share it, remember, at the end of it, if you share that clip, you have gone against the purpose you had given the data subject. You understand? However, if at the beginning you have informed this data subject of why you are collecting and what you're going to do with this data, right? That is called the purpose. Then you eventually share the clip because that was part of the purpose. Then the consent covers even the sharing. You understand? Yeah. So I give you, we seek your consent to record you, maybe to store and retain your clips, so that at the end of it, we may be able to share it on our YouTube channel, we share it on our website, we share it on our social media for our viewers. You understand? So in the end, one consent covers everything, including sharing. But remember, if your consent does not cover the part of sharing, and then eventually you proceed to share, then the data subject has the right to bring a cause against you for sharing his information without his consent. Yeah.
From your own analysis, and I want us to go back to this video in circulation, who would you say is the victim here? Because there's a party that's saying both of them are victims. There's a party that's saying the lady is the victim. There's a party that's saying the man was also allegedly sexually harassed. There's a party that's saying all of them were enjoying what, the exchange that they were having, which of course may appear to be a little bit sexual. So who would you say is a victim in this particular scenario? Is it both? Is it the lady? Is it the man?
There is a quote that Honorable Babu Owino normally likes to make at the floor of the parliament. It is called the principle of volenti non fit injuria. I mean, you voluntarily contribute to your own injury. First of all, let us understand the Kenyan socialite. We are a dynamic society. And a dynamic society is a society that is constantly changing. Now, as society changes, we have conservatives who are there. There are those who view that this lady, for example, she's walking out of her house pantyless, no innerwear, and going to the club. And there are those who are also seeing that her clothes, eventually in that clip you see she's able to push it a little bit and it appears longer. But at the time, the cloth was a little short, meaning there is a way she modified the cloth to look a bit above the knees. You understand? Now, if it was the cloth as original as it was, before the gentleman picks it from down up, she would have been able to put her defenses. Understand? So that is one side of the conservatives, and they are taking it all on her for morality, the morality aspect. And there is this category of people who are specifically looking at the law as it is. And when you look at the law as it is, indeed her rights were violated.
That is dignity.
Yes.
All right.
We talk about dignity and even privacy. Because, if two consenting adults decide to engage into adult content in private, because I doubt, apart from Opande, there is no other person who did the recording, right? From the clip, though it is. And there was trust in between these two people. But then the clip is leaked right from Opande's recording. Then you see there is a violation of her right to privacy. So when it was taken, the legitimate expectation here was that this recording, because after the video doesn't end when she's protesting. Please delete, you understand? You've recorded me, please delete it. No, she's not protesting, right? So what does that mean? That she trusted Opande, that even though she did it at a wrong forum, because her main contestation here from the clip is that the forum was wrong. We are in public, understand? But at the end of it, there was no contestation that the recording was entirely not required by the data subject. So that means that in her mind, she totally trusted who? Opande. To take care of the clip that has been taken, right? But then eventually Opande goes, it's not known whether, because there are rumors that he is saying that his phone was hacked and what have you.
Yes.
Those are speculations. But at the end of it, what is not contested is that the clip came from Opande's side, right? So from Opande's side, the clip is shown online. So that means her right to privacy was indeed violated.
All right.
Yeah.
And when you talk about there's no evidence of the lady protesting, deletion of that video, but let's talk about context manipulation. I know it's a conversation that maybe you've had or you hear every day in the corridors of justice, but how significant is context when determining harm, especially when videos or video clips rather, or messages are shared selectively, or maybe say she did protest deletion, but we didn't watch that part of the video, it wasn't shared. So how is context manipulation determined?
As I said, society is quite an interesting one, because then let's deal with this aspect as it has come. We have seen voices from the Ministry of Gender, you have FIDA, quite a number of voices have been echoed concerning her state at the point of the recording. And some say that at the point she was a bit intoxicated and manipulation came in. Some talk about she was taken advantage of. She was taken advantage of. And I honestly believe that there is nobody that has come out to say that after that session, Naipei was picked up from maybe a mtaro somewhere. It was picked up. I mean, she did not know the way to her home. You understand? Because, when we talk about intoxication, there are tests to it. The law puts you to test. There are elements that must be fulfilled. It is not express that because you are drunk, you are expressly intoxicated. So, indeed, we could say that under the law taken generally, before we go to exemptions and look at the tests and the elements that will have to be questioned here, we would say that she was in a vulnerable condition. Remember I said this on the general context. She was in a vulnerable state. And that happening at that particular condition, then we would say that she was taken advantage of. Her defenses, her guards were down. And indeed she has recourse under the law, even for that context manipulation. So indeed she was manipulated. But remember I said, this is on the general sense. Because when you go to the courts of law, my good friend Omari, whom I revere and always not ashamed to mention him here, he normally has a tagline on his law firm that defense never rests. So there will be questions to be asked. There will be questions to be asked so that we can qualify that indeed the lady was manipulated, the lady was taken advantage of, the lady was intoxicated, and indeed this lady at that point put a question to her. The questions you are asking me now, those are the questions a lay person, a person in right thinking mind. That is the test that we put out there. Is she able to answer correctly the questions you're asking me at her condition? Understand? Remember the conversation that they were having there. Indeed, if the clip is put through the lenses, you will find a few aspects that this lady, if she was intoxicated, it was not so strong. She was able to understand conversation. And she could not deviate from the conversation. Meaning, her mind at that point was able to internalize the environment, to understand what was going on, and to be able to respond to what was going on properly. You understand? So these are some of the tests that courts put up for this issue of intoxication. Yes.
So what can potentially weaken such a case, Wakili? Say in court, we've seen cases of, say, sexual violence for a very long time dismissed in court. What do victims do wrong and we're drawing context from this particular video in question, what will make justice delayed for, say, Marion?
Depending on what she goes for. Like I said, privacy, consent, those are in defamation, those are seriously contestable legal approaches. The one that will be difficult to contend will be dignity. That will be very difficult to contend. And she will have it. A constitutional petition in the line of human dignity. Article 28. When we talk about the right to privacy, I told you it will not be as strong as dignity because of volunteer. That clip checked properly, she contributed to her own injury. Yeah.
Let's also look at Opande. Should, of course, this go the legal way, which, of course, it's going the legal way. Marion has already filed for, things to do with law and justice and whatnot. But what would Opande's charges look like? Should, Marion decide to go the dignity way, as you say, depends on what she goes with, then what would his charges look like?
Well, anybody in the shoes of Opande today would face the sexual offences charges or hefty damages in terms of defamation, because it's defamation of character as well. It is not necessarily you have to write something down or utter something, but even if the character, the image of a person is defamed, because then without the exposure, nobody would look at this woman as an immoral. Understand? I told you the conservative aspect of the society looks at her as immoral, for going to the club with a few clothes. Let me put it like that. There was no completeness of clothes. There are a few clothes she left in the house. And so that is really an exposure of her character. On the privacy aspect, also Pande is at it, although contribution to your own injury doesn't mean that the person is excused entirely. It simply means that if you're supposed to be given 100% damages, the court maybe would decide to give you 50%. The court awards maybe 5 million or 50 million, as my friend put it. That was a serious ambition anyway. 50 million is quite hefty. As a judge, I can't award that. I don't think there is any judge who would do that. But the court awards 50 million and then says you contributed 40%. So at the end of it, what you take home is 60% of the 50 million. So entirely, knowing too well that the exposure came from Opande's gadget, and it's Opande who did what? The recording. If at all it turns out that it is him who did the recording, because it appears that it was him, then he is responsible on the aspect of maintaining the privacy of this lady, which he failed to maintain. So under those aspects, Opande's defenses are quite weak, except of contribution from the other side. But his defenses are quite weak under this because the law is the law. The law is the law. And I normally tell my clients, sometimes you might expect very complex arguments from court. And I will tell them, when the law was developing, it was easy to achieve victory through logic. Just pick up your briefcase, your nice suit and wonderful perfume, and then you go and your lordship, and then you argue logic. Today, you will argue logic, and somebody who does not even know how to speak but has the content of the law carries the day.
That is evidence.
Yeah.
All right. You've mentioned something that if Opande goes to court and proves that he's the one who recorded the video, is there a possibility that, say, if they go to court and deny that he's not the one who took that video, then he can't be excluded from that particular point of recording and sharing?
Exactly. You know, documentary evidence is quite tricky. You see, today we have AI coming up with very wonderful clips, almost true. You look at the clip, the song that has been produced through AI, you look at it and you're like, wow, this is real Akiro singing, and I don't even have skills of singing. You see? Yeah. So if the forensics are not thorough, and forensics leave a loophole, because you don't just go to court with a clip. It will be required that that clip be authenticated. And at that time, Opande isn't aware that it is his phone that recorded the clip. Yeah? He's waiting for he who alleges that is a clip that Opande recorded. To do what? To authenticate the clip. And that will require forensics. To require certificates to be provided and proofs of extraction of that clip from Opande's phone. It will require probably a few witnesses who may have been there when the recording was taking place. It may require quite a lot. If I was on the defense of Opande, we would sit and watch the plaintiffs struggle to prove that the clip came from my client.
Now, of course, people have been looking for his employer to submit these complaints and these videos. But is he likely to lose his job? And if he is, can he contest it? And at the basis of just that video being online?
We are now crossing the borders into the US laws. Yes, what I know that some of the most aggressive privacy laws in the world today, we have the Canadian privacy laws. And then we have the GDPR, that is for the EU, and then I would rank third the US.
Let's look at it from the Kenyan context.
Yes.
If Opande worked in Kenya and that video was circulated online right here in Kenya, and people, championed for his, what is it called? A firing, for him to lose his job, can he contest?
If he loses his job on the spot, the employer will be at fault. Why? Because we have the unaging principle that I spoke to you last time when I was here. You remember? That everybody is innocent until proven guilty. I think what the employer can do is probably suspend him pending investigations. And then the suspension need not to go for a very long time. Some employers would just watch and see what is going on until the court gives a verdict.
That is a paid suspension?
Yes, of course.
All right, as we wind up, of course, and we're coming to the end of this conversation, just for our viewer, what would you leave us with as a guiding principle about, consent and privacy?
Okay, what I would say is that remember that if your creator, I'm a Christian, wanted you to have your privacy exposed, he would have allowed you to think aloud. So whenever you're walking, your thought processes are heard by everybody. But you see, it was his own intention that your acts may be private. And now our constitution, the Constitution of the Republic of Kenya, protects your right to privacy And then we have acts of parliament that also protect your right to privacy. Now, before you give your consent to any collection of your data, remember to get informed reasons why your data has to be collected and for how long it will remain and what will it take for you to get a copy of your data. So these are rights that you have as a Kenyan, as a viewer of TV47. And so in case you realize that your rights have been violated, there are recourse at court. You can always negotiate with the person before moving to court, and then you give them a discharge voucher. That is a disclaimer that having cleared with you, you'll not take him to court. But if he refuses to back up for the damages, you can be able to proceed to court and be awarded serious damages. And remember, you are supposed to be able to review the consent you gave vis-a-vis the actions by the controller, the data controller, or the data processor. Thank you very much.
All right, that is Wakili Cyrus Akiro speaking to us about consent and privacy in the digital age. Wakili is an advocate of the High Court of Kenya. Thank you so much for making time.
Much appreciated.
All right, that brings us to the end of this conversation. My name is Anne Odida. Good morning.